Gentlemen, lovely to see you all here. Sorry for the slight delay. Sadly, the LLM got too excited about something complicated on the institution, and as we're standing outside, I have the great honour and privilege of welcoming my colleague, and it must be said friend, Steve Pearce, who frankly is God in the field of EU law. What Steve doesn't know about EU law, frankly, is not worth knowing. And so, he has an encyclopedic knowledge. Now, I can give you his long CV, but frankly, you want to hear from him, not me. The fact is, he's a star, and we're very lucky to have him. Steve, thank you very much indeed.
Thank you. So, thanks. I thought, to focus on EU citizens and UK citizens' rights and how to enforce those rights. And I'll discuss it not just from an abstract sort of academic point of view, but also very much the point of view of sort of having had a lot of interaction with the public on this issue, mostly in the worst possible place to have an interaction with the public, on Twitter, but sometimes the best possible place. And this is very much one of those topics, or there are others, that are subject to a lot of public misunderstanding and on which a lot of individuals have personal anxiety because, 5 million people are potentially affected by the question of what happens to the rights of the groups of people on both sides after Brexit. And inevitably now becomes a legal question, less theoretical, very much than it was before. Now, should I just press a forward button? Is that right? What should I be doing to... Arrow down. Yes, that says volume down. Should I be looking at it? Oh, here, okay. Sorry. Yes, as an overview, I'll say a little bit, first of all, about UK-EU migration generally, so not specifically for the people who've moved, then about the withdrawal agreement itself, and then briefly put that in the context of national law, the Withdrawal Agreement Act passed last week, the UK national law. Obviously, there's a question of the national law of the member states as well. One point first, although hopefully not too many actual law people get these things confused. The withdrawal agreement going ahead means there's no deal in the original sense of no deal, which means that a lot of plans which countries made and which got publicized and which people have looked at and got worried about no longer are relevant, particularly for citizens' rights. Instead, the withdrawal agreement, the measures implementing it, will apply, which is rather better for many of the people concerned. But not everyone has realized that, and not all the implementation of the deal has happened yet. And so there's still some confusion by individuals. And equally, there's another type of possible fundamental confusion. The withdrawal agreement will stand even if there's no trade deal with the European Union at the end of the year. So all the stuff on citizens' rights and all the stuff in Northern Ireland and so on is there to stay, unless it gets amended. But that's a whole other legal question of whether it could be amended. But it's there to stay regardless of whatever happens to disrupt the trade relationship between the EU and the UK. A lack of trade relationship might have some impact on people providing services, but cross-border, but otherwise not really an impact on the migration law issues. So what about EU and UK migration generally? First of all, there's a transition period in the withdrawal agreement. Free movement fully applies to the end of the year. Now, people are and this applies to the whole of EU law. People are constantly getting confused about this. Some people think that everything stops midnight on Friday, 11 o'clock Friday. But it doesn't. Almost nothing stops at 11 o'clock Friday. There's a possible extension. There's a deadline of June the 30th to agree on the extension, unless you amend the withdrawal agreement. As I say, there's a whole detailed argument about that, whether you could and how you would amend the withdrawal agreement. But I think the more important question is whether it would happen, whether the EU and UK would be willing to do this. And again, there's no early termination. There are some weird people thinking unilateral termination by one side or the other, the UK will be punished. The UK can leave anytime. No, unless, again, you amend the withdrawal agreement, which both sides have to agree to. There's a long argument over whether EU citizenship as distinct from free movement of persons disappears for UK citizens on February the 1st. Probably the majority legal view is that this is really clear. only nationals of member states are citizens of the European Union. It's exactly what the treaty says. But there is a sort of a minority pushback against that view, arguing that in some way UK citizens, or some portion of them, can still remain citizens of the European Union despite not being nationals of a member state. Now, for dual citizens, that's fine. If you're a dual citizen of France, Germany, etc. Ireland, of course, you're still a citizen of the European Union. But otherwise, the majority view is no, that doesn't happen. So the minority argues things like, well, the treaty talks about acquiring EU citizenship, but not about removing it. But it doesn't actually talk about acquiring EU citizenship. It just says that if you're a national of a member state, you're a citizen of the Union. So therefore, if you cease to be a member state, surely you're no longer a citizen of the Union. And if you're looking for a procedure to remove it, look at Article 50, which is the procedure not to be a member state any longer. This is the obvious consequences of it. Article 50, of course, says the treaty shall cease to apply on the date that that country ceases to be a member state. So logically follows that the status of being a member state ceases. The withdrawal agreement keeps it during the transition period for certain things, but not for some aspects of citizenship of the Union, like voting rights. But free movement does still apply throughout the transitional period. And remember, free movement also applies to some other non-EU citizens like Norway and Iceland and Switzerland on the basis of EU treaties with those countries. So it's not only EU citizens that can have free movement. UK, of course, is only going to be in this brief period where UK citizens have free movement without being EU citizens. Now, there are some attempts to push back on this. Some of them have already failed. Cases like Schindler, Walker, some litigation in Amsterdam have failed at several levels in the EU courts. Amsterdam litigation was held back as premature about British citizens in the Netherlands, whether they keep EU citizenship. Now, I imagine someone is going to revive some of this litigation and get a full-on answer from the Court of Justice at some point. So, watch this space. It could be that the majority view is wrong and that at least some British citizens keep their rights. I think there might be a stronger argument for some UK citizens, perhaps even EU citizens in the UK, based on the ECHR, if there's some disruption in their actual life. The Article 8 right to privacy case law says loss of citizenship can be an Article 8 issue, potentially if it messes up your life. Although there's a justification for interfering with Article 8, and all the cases so far have been about people with terrorist convictions, and of course there's a stronger justification there than for the ordinary person for interfering with that. But then does it necessarily, what does it take to resolve the disruption to your life that results from the loss of EU citizenship or the change in status for EU citizens in the UK? So if you have indeed been able to get settled status for EU citizens in the UK, if UK citizens have been able to register at least some of the basics of their immigration status have been resolved. It's the people who didn't get that who would have an Article 8 argument. And now, some UK citizens who have businesses which do cross-border trade within the European Union might have a stronger argument because they lose free movement within the European Union after the transition period. So they might have an argument the loss of EU citizenship, free movement rights as such, is potentially disruptive enough to be an Article 8 point. But resolving that, I don't think, doesn't mean you get to keep your EU citizenship. It may mean you get to keep your free movement, which again can apply to non-EU citizens. And that would be some things the EU could do unilaterally if it wants to for existing UK citizens. Well, I imagine we are going to get those cases in the future and have some kind of resolution of those issues. So what happens after that? Regular UK migration law applies to the EU, whatever that's going to be, and EU member state migration law applies to the UK. What does that mean in practice? We'll break it down by topic. There's a visa waiver for short-term travel adopted for UK citizens already back in April. Lots of people seem to think this doesn't happen, the EU won't do it. There's a kind of recurring obsession, some people on the Remain side, of saying everything that they can imagine in their head that might be bad is definitely going to happen. Even if it's already legislation saying it's not going to happen, they keep repeating this. But it's absolutely clear, having said for 3 years that the EU was pretty much definitely going to have a visa waiver. I was right, they do have a visa waiver. It doesn't stop some people saying that it won't happen, but it has happened. However, fair to point out, if you are a British citizen exercising a paid activity, that law allows member states to require a visa for the person carrying out paid activities. Potentially a mess, at least in some member states, for people doing short-term stuff. The music industry, for instance, and with roadies and so on, really asking a lot of questions about how that might work for them. Border control, you go into the non-EU queue, for instance, but British citizens treated as non-EU, non-visa, non-free movement of persons countries, of which there are quite a few, like the US, Japan, Canada, and so on. Probably the biggest impediment to short-term travel hasn't happened yet. It's what the EU calls the ETIAS system, the travel authorization system, which you'll have encountered if you've traveled to the US or Canada, perhaps a couple of other countries, having already set up their system. There will be an EU version and an entry-exit system accompanying it. So that is a couple of things about that. First of all, there's a proportion of public opinion which says, my God, that's the mean EU punishing us. And I think the response to that is, take some responsibility for what you voted for, because this is the foreseeable consequence of what you voted for. It is exactly what you voted for, at least for those people who wanted to be a non-EU country without free movement, or those who voted to leave, hoping that we'd stay in the EEA, that not sure I could measure the amount of naivety in that kind of thinking. But for those who didn't, and that a lot of people say they didn't want to keep free movement, this is exactly the position you're in. You wanted to be a non-EU country without free movement. You are now a non-EU country without free movement, treated exactly the same as all the other non-EU countries without free movement. I mean, some people are okay with it, but some people still whine, and that's irritating. A second point, and this I only just noticed this recently. There is an exemption. This crosses over with withdrawal agreement. There is an exemption. You don't have to apply the ETIAS system, the entry-exit system, for those with a residence permit. So British citizens who get a residence permit to stay in the EU, or stay in Schengen states of the EU, aren't going to have to be subject to this system. And that's the same for anyone with a residence permit, Americans, Indians, and so on, with a residence permit from a Schengen state. Now, I have people who keep arguing with me about this and saying, but the ETIAS people say that that's not true. I'm going to figure it out because I keep looking at the legislation and the exemptions there. So who are these ETIAS people? So someone directed me to a website, etias.com, which contains the false claim all British citizens will need to get travel authorization, because a whole bunch of other false claims. If you want to stay for more than 30 days, for more than 90 days, you need a Schengen visa. No, the Schengen Convention has said for 25 years, you need a national visa if you want to stay for more than 90 days. If you try and apply for a Schengen visa, you will be throwing €60 away because you won't get your application fee back, because you can only apply for a Schengen visa for a shorter period. That's what they are. So who is this ETIAS? And I really went around and found the front page of the website, and we're not affiliated to any member state or the EU. So this is either a hobby or some kind of long-term grifting opportunity by some people who want to charge and make a buck. And I have a real problem with people who don't tell the truth about immigration law. It can really mess people's lives up. You can imagine people finding this website probably first thing on a Google search and getting misled and confused, as people already have done. It can really start to happen once that system is set up. Everyone who travels to the EU has to go through the system. And British citizens in the EU are already going to start to get confused. So, and I contacted the immigration lawyers and said, well, look, these guys have an office in London. Maybe the solicitors, regulators can have something to say about this, because there's a phenomenon of bad immigration advice. And they came back to me and said, oh, it looks like there's 76,000 companies at that address. So I'm starting to think these people might be fishy. And apparently, there are people expecting dozens of this sort of thing to pop up. And you can imagine it in other areas as well, where people are going to get a lot of bad advice by, dodgy people, either trying to scare them or trying to get rid of them, or, trying to make a buck. Or just confused. And that's constantly battling against. Otherwise, for UK citizens who move to the EU, what about long-term migration? Well, you have member states' law, you have EU law, which partly harmonizes member states' law. My pet peeve is the people who tell me there's no such thing as EU migration law, partly harmonizing member states' law. Having written about it for 25 years, this comes as a surprise. Anyway, the EU can't do anything with non-EU citizens. They're confused by the fact the UK has opted out of most of that stuff, perhaps. But in any event, there is legislation on asylum. There's the fringe of Remainers who think, aha, I'm just going to go and apply for asylum, having no knowledge of refugee law. Someone was mean to me on Twitter. That's persecution under the terms of it. But no, it doesn't quite amount to persecution. Persecution would be things like violence, which isn't. And threats and so on, which aren't dealt with properly by the law. There is violence and threats, but it is, are people getting prosecuted for cases where it happens and police to investigate it in this country? So it's not very strong argument as things stand. The law on illegal migration would apply, notably the Returns Directive, which deals with things like detention, expulsion, entry bans for non-EU citizens. Now, you encounter this argument all the time from the Leave side. Some people on the Leave side, that there's no problem for UK citizens moving to the EU in the future, because the thing about migration law is you just fill in a form. I call this the just fill in a form trope. Now, the reason they believe this is perhaps because they also believe that the European Union lets in everyone from around the world with no constraints whatsoever. And so millions and millions of people are coming and killing everyone from around the world. But of course, the EU doesn't do that. In fact, there are some people come. But of course, there are border controls. Why else are people drowning in the Mediterranean? Why else are people in camps in Greece and indeed in detention centres across the European Union, immigration detention centres? It's not because someone didn't give them a form or they didn't know about the form. So this is a really quite striking failure to understand. Of course, the underlying point is true that it will still be possible to move, but you will have to meet more stringent rules to move, which go beyond filling out a form. It's fine, of course, if you meet the criteria fairly easily, but some people will. But for those who don't, and that will be some of those who can move now, won't meet the criteria, you're going to have problems. And there's a whole bunch of areas of legal migration which the EU has partly harmonized for non-EU citizens, so British people might have to become a little bit more familiar with them. But if you marry a home state national, marry German in Germany, national law applies in principle. Another feature which I'm noticing a lot of people don't know, I mean, every EU law person knows it, but a lot of other normal people don't know this, is that free movement law can still give UK citizens rights, their derived rights, the same as if we were Indian or Japanese, as a non-EU family member of an EU citizen who has exercised free movement rights. So they have to be someone who's left their member state. Every EU law student learns this. Of course, not everyone becomes an EU law student, so that comes as a great surprise. People get asking to prove it. They just can't quite believe it. But it's true, of course. As long as, of course, that EU citizen meets the conditions to go to another member state, which are quite liberal, the law says it also applies when you come back to your home member state. And here's my first sort of legal question. What if you're in this case, the Dutch citizen benefits from a more liberal migration law because they moved to the UK, married someone from Suriname? What if they then come back to the Netherlands? Fine, EU law still applies. But because they've gone to a member state and come back. But post-transition period, can it still be said they've gone to a member state and come back? Because the UK is no longer a member state. Can you say it's sufficient that they went there while it was a member state and came back after? At least there is some connection to a member state historically. Can you really say that group of people are covered or not? Do we say that's it? It's no longer a member state? There's a couple of other areas where that comes up. All right, dual citizens I've mentioned already. So I move on to the withdrawal agreement. I'll say a little bit first about the sort of general legal issues here. The Court of Justice retains jurisdiction over the UK. This is from the national courts, not infringement actions, from the national courts from the UK for 8 years after the end of the transition period. And as any court or tribunal that can still send questions, the top courts no longer have an obligation, but that was never very strongly enforced anyway. So on all the citizens' rights parts I'm talking about, not the rest of it, that's mostly not subject much to the court's jurisdiction in the UK. There's also going to be this independent monitoring body set up to help EU 27 citizens in the UK and in terms of their rights under the withdrawal agreement, which will have quite a few powers to intervene in cases, to bring cases and so on, to sort of raise issues. I was looking yesterday at an article about this monitoring body because I'm quite intrigued about how it's going to work. And apparently they're going to hire 200 people. I'm guessing that's just about enough to hoover up every EU law academic in the UK, although it is going to be located in Swansea. So I'm not sure they all want to move to Swansea. And some of us, we might have to spend time deleting tweets first if we are to have any chance of being appointed by the Home Secretary. But, anyway, it's supposed to have similar powers to the Commission. It's roughly similar to what the Commission can do. The withdrawal agreement goes on to say references to EU law must be interpreted the same way. So this isn't some kind of new, totally different type of migration status. And some people have this impression that, it's all national law now. It's not all national law now. For those covered by the withdrawal agreement, it's basically, with some limitations, basically EU law that applies. And there are lots of references to EU law. There's hundreds of them in the citizens' rights bit, elsewhere too. But in the citizens' rights bit, there's loads and loads of references to explicit legislation. So interpreted the same and consistently with prior case law. So what about prior case law? What's the definition of a worker? What's the definition of a marriage? Does it cover same-sex marriage? Yes. That case law all continues to apply to those covered if you bring yourself within the scope of the withdrawal agreement. The same legal effect as EU law, it says. The UK has to adopt an act of parliament, which was just done last week. Same legal effect means direct effect and supremacy. So the people who had to, who were very frustrated by that notion of EU law had to accept it, and they did accept it for the limited purposes of the withdrawal agreement. Now, what about the EU side? What about British citizens? Well, the case law and external relations says an international treaty has direct effect if it has the aim and purpose of conferring rights on individuals. It looks very much to me like the citizens' rights provisions meet that test. There's loads and loads of descriptions of people's rights and what the EU member states shall do for UK citizens. And we definitely know international treaties signed by the EU have subject to the jurisdiction of the Court of Justice. And that's, of course, from the EU member state courts and the Commission's power to bring infringement proceedings as far as that is concerned. Okay, so what about the substance of the withdrawal agreement? Well, it applies to those who move, as I said, before the end of the transition period, including their family members. There are some conditions, so there is a kind of cut-off for family members. You either have to be already resident then, that family member, or already a family member. So, you could have a spouse who hasn't, still in Poland, hasn't yet joined you, as long as they are your spouse. At the end of the transition period, they can join you in a year or two later. Fine, so final cut-off on when they can join you. Or someone who's born out, children who are born later are still covered, as long as the parent has withdrawal agreement acquired rights. Now, here's one of my other questions about what does it mean to refer to a member state? Because the case law said, yes, same-sex marriages are covered by free movement law, but the same-sex marriage has to be under the law of a member state. Okay, well, what happens now that the UK post-transition is no longer a member state? Do we still say that anyone who's got married under the different laws, different parts of the UK, all of them now, is covered by their same-sex marriage was under the law of a member state? It doesn't matter when it took place. As long as it's covered, let's say, when it took place before the end of 2020, then the UK was a member state as a member, or for the purposes of the withdrawal agreement, then it ceased to be. Do we say that? The most extreme interpretation would be even those who've already moved, who got married under British law, who would be sitting, a French-British couple sitting in Germany, are no longer covered by free movement law because the UK is no longer a member state. I think that's quite a severe interpretation that would remove residents' rights and people who are already present legally. That can't be correct. So there has to be some kind of, but it's not obvious what the interpretation of that is. Okay, what else happens? Well, I won't go through all the details because it is quite a lengthy chunk of the withdrawal agreement. Basically, residents' rights are retained as under the treaties, citizens' directives, some other legislation too, on workers, for instance. And there's no general discretion. And sometimes people say, oh, well, the UK can just throw me out. No, it could just refuse to be settled status. No, it can't. And neither can the member states just refuse UK citizens they don't have any residual discretion. There are some grounds of refusing, such as criminality or not being there previously, coming after the transition period, not being a genuine family member, fraud, and so on. But there's no general discretion to refuse. There's no general discretion to remove the status. The Home Secretary can't wake up tomorrow and say, I'm getting rid of 100 French people today to feel good about myself. No, this is not possible. The same rules for getting permanent residence, and you don't lose it until you leave for 5 years. The moment you lose it if you leave for 2 years. Now, of course, the underlying, that in a way reflects the underlying change, masks the underlying change, that you no longer have a core free movement right. It doesn't matter that much if you lose permanent residence at the moment, having a French person leaving the UK for 2 years, if they can come back. Of course, they can't post-transition period, so it's quite significant to say that you have this longer period to keep your permanent residence. You can change status. There are, and I think it's going to be the core for a long time, but certainly the next year and a half, is the settled status process of EU citizens applying and getting status in the UK, and the equivalent status, which will take different national forms of UK citizens registering or applying in member states. And that's going to give rise to a host of practical questions and concerns, some of which, of course, are already getting reflected in the press. And I think, the 2.8 million people have applied. These are very much likely to be the low-hanging fruit of the EU citizens in the UK. The people those who knew about this got settled status quite easily, which is some of them. But there are a number of people who get pre-settled status, which is less secure, not totally insecure, which means you simply haven't qualified for permanent residence yet. There's a big question over whether those are all the right decisions, because the software for a long time was badly designed. It didn't ask at the outset, how long have you been here? It didn't ask at all, how long have you been here, which is a crucial question for whether you get permanent residence. It also matters how you've been here. But that's the starting point. Have you been here 5 years at all? So some people might, having not seen that question there, only supplied information for the last 2 years, and thought, well, that's fine. And then the system comes back and says, okay, you've shown us information for the last 2 years, you get pre-settled status. Now, they have redesigned it, but a number of people would have got pre-settled status who shouldn't, perhaps, and should have got permanent resident status. There are also people who don't understand and apply for the wrong thing. There was one case covered in the press last week about a chef who applied for the wrong thing. He applied for permanent resident status under free movement law rather than settled status, and he was told no. And he didn't send enough information anyway. And he freaked out. This was kind of a cold slab. But in part, that was his own misunderstanding, which shows you that genuinely people do misunderstand things. It's not such a profound misunderstanding, because he was actually applying something that was open to him. It wasn't something that's very much used to him anymore. And he didn't quite understand. It's an 83-page form that you go through for permanent residence. So it's understandable someone could make a mistake. But also the Home Office sent him a letter saying, oh, well, you can apply for something else that we're going to set up later. Well, hold on, but settled status has been running for nearly a year, fully. So why are you telling someone, oh, well, you can apply for something later? That's kind of highly anxiety-producing, and it's simply inaccurate. The idea of the Home Office sending that kind of inaccurate, profoundly misleading and inaccurate letter to people at the same time as rejecting them for something else is highly problematic, that this is we're at this level of administration. Because there are going to be all sorts of questions about people who don't know about it, who don't understand it, make a mistake. As the people who would have a criminal record are probably going to be holding back in applying because they know they'll get caught. But this is not a huge proportion on either side of the people involved. And a lot of children in care are a particular issue. There's a number of Brits in Spain who haven't fully registered there and are now going to have to sort of make a choice. If you want settled status in order to go to Spain for longer than 3 months and every 6, you're going to have to choose whether you get settled status or not. And they may have been arranging their affairs in such a way which wasn't hugely legal in terms of tax or something else. And that's a situation that they'll have to resolve if they want to get that sort of ongoing status. What about criminal behaviour? As I say, before the end of the transition period, you want to get your low to medium crimes done before then, because the EU standards will apply then. In that case, it's quite difficult to expel someone. After that, national standards apply, usually a lower threshold to expel someone. So that's an immediate change in a way for anyone who commits crimes. This was a big issue. Rights to appeal still apply. There was a misunderstanding when the Withdrawal Agreement Act was passed. The UK government wasn't going to legislate for it. It's in planning to do it in secondary legislation. Simply didn't want it in primary law. I think it would be better in primary law, but it's not as if you can't conclude from that it's never going to happen, because there's powers to do it in primary law, and the government plans to do it. And this gives rise to kind of more general question of concerns about the rule of law. And I can, do we even believe the UK government? There is this sort of widespread disbelief in the UK government, or in the fact that a law has been passed as actually meaning anything. And in a way, I can understand that, because the people who are putting the system up are the people who lied about it to both groups of people and cheated, broke the law themselves in terms of election spending. Why would you necessarily try? It's quite reasonable not to trust them. But having said that, look, and the withdrawal agreement is about to be ratified, and the Act of Parliament has been passed, and that, legally speaking, does create something. Of course, there are issues with application and access to justice issues. So, solving a law does not solve everything, but it does accomplish something. It does have some impact on how courts work and how, what the impact is of a lawyer writing a letter on your behalf and trying to get things sorted out, and how civil servants apply the law. To say it has no impact, or the government will just ignore it, as if we don't have any courts at all, and as if everyone has contempt with the rule of law across the entire civil service and judiciary. It's far too sweeping a statement. Of course, there'll be problems with implementation. I expect some really outrageous cases of the law not being applied well. But to say it won't be applied at all, it's such a sweeping, unsubstantiated statement. Right, access to employment and equal treatment rules still apply. I think a point, as is really becoming obvious, is whether there's horizontal direct effect against private parties. Now, we know there is against employers in the treaties and the regulations on workers, and that gets copied into the withdrawal agreement. What about everyone else? What about landlords? And what about banks, who are apparently often saying to people, EU citizens, we're not going to give you a mortgage because we're not sure about whether you're going to be around here or thrown out. Can we say that they're also bound by the withdrawal agreement, or can we use the Act of Parliament implementing it here to use against them? I think there's arguments there. We have to obviously put them in a way that can easily be communicated. You can't expect an EU citizen to walk into a bank and say, well, this has horizontal direct effect, and expect the mortgage guy to respond to that and give them a mortgage. No, it has to be something put in the language of the coming from the FSA or somebody at the Home Office that clarifies this very clearly for landlords and banks. What we unfortunately tend to get from the government is people saying, this is fine, you're all scaremongering. Stop scaremongering. The security minister and I have this thing on Twitter, we each keep calling each other liars. It's very exciting, but this doesn't really get us anywhere. And in terms of trying to resolve the problem that individuals face in individual cases. Right, the withdrawal agreement also provides for recognition of qualifications. Again, it has to be something you've got or applied for to recognise before the end of the transition period. So a French person who decides in 2 years' time they want to return to France or Germany with their British qualification, that's not going to be covered by the withdrawal agreement. Social security coordination, that's kind of a big issue. This constant argument that you hear, oh, well, look at those Brits in Spain. They're all going to have to come back here and flood the NHS. These 40 new hospitals, I guess, will be full of that. Now, no, because social security coordination is kept. That includes pension upgrading. That includes S1 forms for healthcare. Now, those would both have been limited if we had no deal, but we don't have no deal. We have a withdrawal agreement, and all that's covered. Now, then there will be some issues for some of those people registering in Spain, so they're definitely covered by the agreement. You can't sort of waft around the grey economy in quite the same way as you might have done before. But obviously, for those who are able to do that, that's fine. Now, you don't have free movement, as I've said, within the EU for UK citizens, rights in one member state only. Obviously, limitation I've already touched on. You can become a long-term resident under EU law. There's some interesting questions exactly how the EU law on non-EU citizens works coalescing with the withdrawal agreement, but it should in principle apply. So you have limited free movement rights, nothing quite like being an EU citizen. And finally, the Withdrawal Agreement Act, just to summarize it, switches on the European Communities Act for the transition period then off, keeps EU legislation in domestic law for the transition period. The rest of the withdrawal agreement, there's a general implementation clause brought into British law in a very strong way. And see also specific provisions on citizens' rights. There were parallel treaties for Norwegians, Icelandic, Swiss, Liechtenstein people that the UK has signed, also put into domestic law. Settled status scheme is out there already in the immigration rules, so it's quite time to hear people say, well, all be illegal because the immigration rules have provided for this for some time. Hopefully everyone's got past that thinking everyone's illegal. There's a series of powers to implement the specifics of the withdrawal agreement, all of which make lots of cross-references. So in many ways, then the settled status scheme has been entrenched into the primary law, the Act of Parliament of the UK. Of course, the government can try and ask Parliament to amend Acts of Parliament. They're not that easy to amend. The Home Secretary can't wake up tomorrow and say, well, actually, I'm going to start expelling these people. No, you have to act consistently with the Act of Parliament. Now, a really obnoxious decision by the Home Secretary, but then still have to be challenged in the courts and so on. It might take some time to you can't be sure of success. But nevertheless, there isn't some kind of general power to do anything. There's a lot of primary law constraining what the government might do, including this point about how you expel people. No general power to expel. Primary law restricts it to the provisions of the withdrawal agreement. And there's also power to act on professional qualifications, equal treatment, social security, and the independent monitoring body. The final point is a point which a lot of lawyers have picked up on, and some people have written inaccurately about on this issue, is that there is now a power for lower courts to amend existing EU law and for ministers to tell them how to amend existing EU law after the transition period. Now, lots of ways this could be used. I can understand lots of people in the employment, environmental, food standards area wondering what does this mean. But in terms of the withdrawal agreement, especially the citizens' rights provisions, it doesn't apply. To be able to miss this, there's a second paragraph saying this doesn't apply to the withdrawal agreement, including citizens' rights. So we don't need to be concerned that, unless they try something illegal, but legally speaking, they shouldn't try and use this power to tell national courts, oh, those people are no longer workers because they're part-time or whatever. They are bound by the withdrawal agreement. So hopefully that's useful, and I've left some time to to discuss topics. I don't know how long do we have to?
Yeah, but another 10
okay. But I'm happy to answer questions or hear any observations that anyone else has.
Well, thank you very much indeed for that. I think a round of applause for such.